Good afternoon, everybody. Thanks for joining us today for the first webinar in Conn Maciel Carey's 2017 OSHA webinar series. I recognize an awful lot of the names on here of folks who have joined us over the past couple of years for the series, and I'm delighted to have you back, and that tells me that you're not annoyed by what we've been doing, and I'm glad that you're able to join us again this year. I'm excited also today to be joined by quite a few of my colleagues in Conn Maciel Carey's national OSHA practice to present on interesting and exciting OSHA topics to track in 2017. We have done this program the last few years, sort of talking about what did we learn from OSHA in the previous year and what can we expect to see from OSHA in the upcoming year. And I can say honestly that it's never been more difficult or more challenging to come up with a meaningful forecast for what to expect in the upcoming year. We find ourselves in an unusual time in history, an unusual time in OSHA's history, where it is a little bit harder to forecast what to expect than in previous years. And perhaps also as we look back at the prior year, maybe less relevant and less informative what we learned in 2016 as to what we might see in 2017. So we'll do our best today to give you the lay of the land as we move from the Obama administration to the Trump administration, and what we learned at the end of the Obama administration about OSHA, about the direction that OSHA has been heading, and where we expect where we expect we'll be going from there. So we'll just jump right in real quickly. I'll introduce myself now, and the rest of the team will introduce themselves as we get to different sections in the presentation. So the first faceless voice that you're hearing from today is Eric Conn. I'm one of the founding partners of Conn Maciel Carey and chair of the firm's National OSHA Practice Group. I represent employers in all facets of workplace safety and health law issues, from inspections, investigations, enforcement actions, criminal investigations, audits, rulemaking, interpretation letters, variances, and the like. And I'm pleased to be joined by several of my colleagues today who will introduce themselves in a moment. And here's what we're going to be talking about. We'll take a quick look back at 2016. We usually spend a little bit more time looking back at the prior year, but as I said, I think it may be less informative as to what we can expect in the coming year, but we will look at sort of where things ended, the note that the Obama administration ended as it relates to OSHA, some enforcement data and trends, and some major rulemaking and legislative developments. And then we'll kick into, forward-looking. What do we expect is going to happen in 2017, the inaugural year of the Trump administration, and the top 5 OSHA issues to track in that regard. And here's the 5 that are unveiled here for the first time that we think is a major shift in the enforcement philosophy. We'll talk a little bit about. We'll talk a little bit about how the Obama administration's OSHA used public shaming as an enforcement tool, and how we expect that may change in 2017 and going forward in the Trump administration. We'll talk a little bit about changes during the Obama administration to unions' inspection rights, in particular rights at non-union facilities, and what we expect will happen going forward under the Trump administration. Then we'll talk about the new record-keeping rule that includes anti-retaliation elements, and particularly the controversial drug testing, post-incident drug testing, and safety incentive elements, what we expect is going to happen with that rule under the new administration. And then finally, if you've heard me talk about OSHA over the last 8 years, you've heard me talk perhaps obsessively about the agency's approach to finding and citing repeat violations. So we'll talk a little bit about that recent history and then how we think that may change under the Trump administration. So I'm going to start off talking a little bit about what we learned from OSHA in 2016, so looking back to see if perhaps there are some lessons learned there. This is a data point that we track every year, and it's interesting. This is the total federal OSHA inspections conducted over the course of the year. And one thing that has been sort of fascinating about this trend, as you know, you've heard us talk about how OSHA during the Obama administration has been very enforcement heavy, perhaps enforcement only mentality, but the number of inspections that have been conducted has gone down steadily since 2012. And I understand that, the first couple of years where the data was trending down had to do with the government shutdown and the sequester. And I think that the trend downwards still has something to do with the sequester, but I think it also has a lot to do with some difference in how OSHA was conducting each individual inspection. You may have read an article on our blog about OSHA's weighting system, where they are giving different weight or credit to area offices around the country for doing different types of inspections. So more resource-intensive inspections get additional credit towards each office's expectation for the number of inspections that they will do, as a way to encourage more complex inspections about more complex topics. So rather than the drive-by, quick-hit construction site inspection, OSHA was trying to encourage more process safety management inspections involving general duty clause issues. So as a result of that, there was a significant increase in man-hours per inspection, but a decrease steadily of the total number of inspections. So we saw that that number was trending down. I actually think going forward that number is going to continue to trend down, but perhaps for different reasons, foreseeing perhaps a different prioritization by the agency under the Trump administration from a less enforcement focused, less enforcement exclusive to some other tools to advance the safety and health mission of the agency. So, we've watched a trend over the balance of the last 4 years of the Obama administration. That's a trend that probably will continue. The total number of violations issued similarly has trended down since 2012, 2013 in the context, again, I think fewer inspections meant fewer violations. But again, I think we were seeing different types of violations, perhaps more general duty clause violations, more violations in that process safety management category, and things like that that are more involved, that require inspections that take a little bit more time. So the gross number of inspections did decrease over the years, and we saw the lowest point during the entire Obama administration, just under 60,000 total violations issued in fiscal year 2016. Data point here that I always find fascinating, not because it changes and it's any kind of roller coaster at all, but because it just always amazes me how incredibly difficult it is for an employer to go through an OSHA inspection and not be cited at all. This is the percentage of in-compliance inspections, meaning an inspection occurred, and at the end of that inspection, OSHA decided that it would not issue any citations at all. And you can see that that was at 25% in fiscal year 2016, meaning 75% of all inspections that were opened, OSHA found at least one violation, or alleged at least one violation. And you hear the stories from the field all the time where the compliance officer says, hey, I can't leave until I find something. I got to prove to my boss that I was here. So it is very hard to escape an OSHA violation without a violation, and you see that year over year over year, it is an extremely high percentage of inspections are opened with at least one citation issued. Aside from just the data, there are some interesting developments over the course of 2016 that we'll talk about. And one, as hopefully you all are already aware, but back in August of this year, August of 2016, OSHA, along with most other agencies in the executive branch, increased their civil penalties. But OSHA's increase in civil penalties was probably the most stark and the most significant of any other agency. And the reason that this happened was as Congress was staring down the barrel of another government shutdown, the Republicans in Congress, or really the Republican leadership in Congress, who felt that they wore the brunt of the prior shutdown. The public opinion was negative about the shutdown, and it was particularly negative towards Republicans in Congress. were set on avoiding another government shutdown, so they brokered a deal with President Obama and the Democrats to include in to reach a bipartisan budget act. And one of the concessions that the Republicans in Congress made to enable the bipartisan budget act to be implemented, to be agreed upon, and thereby avoid a government shutdown, was to include an element in that act called the Civil Monetary Penalties Inflation Adjustment Act. And what that piece of legislation did is it did not authorize or allow, it required all federal agencies to increase their maximum civil penalties to catch up with the cost of living based on the Consumer Price Index since the last time that penalties were increased. And for OSHA had been frozen in time since 1990. A lot of other agencies do more frequent, more periodic updates to civil penalties, so they may have increased their penalties by a small amount. OSHA had not increased its penalties since 1990, so they looked at what was the percent change in the Consumer Price Index since the last time we raised our penalties in 1990, and that was a little more than a 78% increase in CPI, which meant Congress was mandating that OSHA do a one-time catch-up civil penalty increase of a little more than 78%. And so that translated in a very significant increase in the maximum allowable civil penalties that OSHA could issue. The other thing that the law did was it mandate an automatic annual increase in January of every year, again based on change in CPI over the course of the last year, and that has already been implemented for 2017. So the jump in CPI from 2016 to 2017 was another 1%, and so earlier this month, OSHA announced another penalty increase, this time only of 1%. So where does that leave penalties? Since 1990, OSHA civil penalties look like this first column. $7,000 maximum civil penalties for other than serious and serious violations, $70,000 penalties for willful and repeat violations, and $7,000 per day violations for failure to abate notices. The first increase, the 78% bumped the penalties up to around $12,500, and the new 1% increase leaves penalties at a little bit over $12,600 per other than serious and serious violation, and now a little over $126,000 per willful and repeat violation. And similarly, $12,600 per day for failure to abate violations. The result of this change was that we saw essentially every metric where you measure OSHA civil penalties to also increase. Looking at the average penalty per serious violation jumped up, and you can see that this was jumping up over the entire course of the Obama administration. You saw at the end of the Bush administration less than $1,000 per serious violation. That has more than tripled under the Obama administration and jumped a meaningful amount between 15 and 16. And remember, the 2016 data is not a full year with the new penalty authority, so I expect that this number will jump again in 2017, even as we transition to the Trump administration. So that's a per violation number. Another interesting number is significant cases. That's where the total cumulative penalties for a matter resulting from an inspection was $100,000 or more, and we saw another year over 150 of those $100,000 cases. And I'll have a slide in here that shows sort of the difference between pre-August and post-August, which is some pretty interesting data. The $1 million cases we track every year. That used to be extremely rare prior to the Obama administration. This is 7 years under the at the end of the Bush administration. The majority of the Bush administration, you saw about two to three at most $1 million cases a year. Corresponding 7 years at the end of the Obama administration, saw about 60 of those. So more than tripling the number of $1 million cases. And it used to be really difficult to cobble together enough $7,000 and $70,000 penalties to make $1 million case but the Obama administration found a way to do that 3 times more often than the Bush administration had. This is, I thought, a kind of interesting slide. Was anecdotally, you watch these press releases that come out, you started seeing these $250,000, $300,000, $400,000 cases at a rate like we never saw before. It used to be you'd get that $110,000 penalty or one of those big $1 million cases and a smattering of the several $100,000 cases. Well, just in the difference between the time the civil penalties were increased, you saw about a 3-time increase in the number of $250,000 plus cases. So, if this is the trend, if it continues, and again, these are maximum penalties, so you never know what's going to happen under the Trump administration, but you can see that it is a whole lot easier for OSHA to cobble together civil penalties that that will raise that red flag, that will have a significant impact even on medium-sized and bigger companies than they have been able to do in the past. So some interesting data, I thought, tracking 2016. The last thing I'll talk about, sort of looking backwards at what's going on from a 2016 standpoint, was one of the most significant years in OSHA rulemaking perhaps ever. There was that period at the beginning of the agency where they adopted a bunch of industry consensus standards. Certainly nothing could ever challenge that year. I cannot remember another year where more rules were finalized than 2016, and it's obviously not a coincidence that it was the tail end of an administration of one party moving to the administration of another party. We look at all these new rules that happened, and frankly, they all sort of happened at the very end of the year. And we had pretty decent information from folks at OSHA that we were not going to see more than 2 or 3 rules go to OMB, go through OIRA, and become published in 2016. I think because there was an expectation that Hillary Clinton would be our next president, and rules could be carried on from where they were left by the Obama administration and finalized early in a Clinton administration. And there was a desire to not have too many new regulations in an election year, to not remind employers and workers and voters about the burden of regulation. But after the election and before the inauguration of Donald Trump, we saw an awful lot of rules get finalized, and finalized with really, really fast effective dates. A period of time between publishing the rule and the effective date, and an awful lot of rules that magically became effective the day before or 2 days before the inauguration. So really interesting political atmosphere during this election year and the transition into the new administration. These are a few of the rules that we thought were really significant in 2016 or the very beginning of 2017. There's the new electronic record-keeping data submission rule, and we'll be talking about that rule during this presentation in more detail, but just to note that in 2016 this rule was finalized and published, and it is rolling out, supposed to roll out in 2017, and we'll talk a little bit about what is actually going to happen with that rule going forward. Under that same heading, as part of the same rulemaking, there were these anti-retaliation elements to injury and illness record keeping, more specifically to reporting injuries and not being retaliated against as a part of that reporting process. That was a significant new rule that we will talk about in more detail in this presentation about what's going to happen with that rule going forward. The silica rule, published earlier in the year. Legal challenge is active on that rule, but that was a major rulemaking effort at the culmination of many years of rulemaking, finalized during the final year of the Obama administration. And then, the rule that looks to me to be the most like a midnight rulemaking slammed through very quickly, finalized in the final days of the Obama administration, effective 2 days before Trump's inauguration, is the Volks, I call it colloquially the Volks rule. This was OSHA's effort to try to undermine the D.C. Circuit's decision in Volks, which clarified, the D.C. Circuit clarified what the OSHA Act meant and what OSHA's record-keeping regulations meant in terms of the 6-month statute of limitations. OSHA had historically interpreted that rule to include a 5-year, 6-month, and 7-day statute of limitations based on the duty to keep physical custody of your injury record-keeping logs for 5 years. But in fact, the D.C. Circuit said, no, the 6-month statute of limitations that applies to all OSHA enforcement applies in a strict sense to record-keeping rules. So rather than 5 years, 6 months, and a week, the statute of limitations is 6 months from the occurrence of a violation. So it is 6 months and a week from the day of a recordable injury. That is the period of time that OSHA has to enforce a violation of the record-keeping standard. OSHA, rather than appealing that case to the Supreme Court or even petitioning for a hearing en banc with the D.C. Circuit, they just said, okay, we'll just do a rulemaking to basically overrule the D.C. Circuit's decision, which was an interpretation of the OSHA Act. So we believe, many people believe, that that is an unlawful rule that we expect will be challenged early here in the Trump administration. But that was another significant development in 2016. So looking ahead to 2017, I'm going to cover the first topic, and that is, just generally speaking, a change in the enforcement philosophy at the agency. We saw a transition from President George W. Bush to President Obama, realized a major shift in priorities, budget resources, philosophy from the standpoint of enforcement, from a balanced approach under the Bush administration to using enforcement and compliance assistance and cooperative programs and a litany of tools, a toolbox full of tools to advance the safety and health mission, to a transition under the Obama administration to, if not enforcement only, to certainly enforcement heavy. A strong favoritism towards to the hammer rather than the stick, rather than the cooperative approach, and that meant hiring significant number of new compliance officers, developing policies that would allow them to raise their penalties, raising average penalties, minimum penalties, getting rid of penalty reductions, developing policies to advance more criminal cases, criminal referrals and investigations. We saw absolutely a spike in significant cases, egregious cases, $1-million cases. We saw an advancement of many new enforcement initiatives and in emphasis programs. Went from seeing an active, 3, 4, 5 national emphasis programs to sometimes as many as 20 active national emphasis programs and dozens of regional and local emphasis programs, all advancing the enforcement mission of the agency. We also saw some changes in the way OSHA looked at employers to find and cite more repeat violations, and we expect that we will, and we're going to talk about that in some more detail today as well. So that's what we saw between Bush and Obama administrations. Now let's look forward in 2017 to what we can expect in a transition from an Obama to Trump administration and a Secretary of Labor, Puzder, assuming he is confirmed early in February. What I would expect to see is scaling back the Obama-era enforcement philosophy. If not a literal scaling back of budget, then certainly a reprioritization, a shifting of resources, shifting of budget dollars, shifting of personnel, signals to the regulated community about a change in the way the agency feels and thinks about programs like VPP and the compliance assistance inspection programs. There was a obvious chilling signal from the Obama administration's OSHA about VPP. They just were not fans of the program. They felt it was too easy for employers to qualify in, too difficult for them to be excluded, and felt like they got egg on their face every time a VPP employer had an incident or something like that. And so they took steps to kick people out, make it harder to get in, and to really diminish the value of being in. There used to be exclusions from most inspections, those exclusions were chipped away at, and it just became a disfavored program. I think that attitude will change significantly. VPP will be favored again under the new administration, and employers who are in the program will get the benefit of the doubt again, and it will be a better program. Compliance assistance, I think they'll see a lot more money and resources in that, where OSHA comes in, or some quasi-OSHA entity comes in, does an enforcement type of inspection, but at the end of the process there are recommendations for improvement rather than civil penalties and litigation to follow. We will see a shift back in that regard. I also think that we're going to reopen the Field Operations Manual and change a lot of the policies and enforcement programs that were advanced or modified under the Obama administration. For example, the penalty reductions that were available that were changed under the Obama administration, how you calculate minimum penalties, how you conduct inspections, how you select inspection targets, and certainly the focus on repeat violations that we'll talk about in detail today. I see a lot of that changing as we move forward with a Trump administration. So that was sort of my high-level philosophical view of what to expect under the Trump administration. And now the rest of my team is going to talk about some specific rules, some specific concepts in OSHA that we think will change going forward. And I'll turn it over now to Lindsay DeSalvo.
Good afternoon, everyone. So I'm going to take some time now to go through our thoughts on how we think we could see the policy of public shaming change under the new administration. So first, just a little background on me. As Eric said, my name is Lindsay DeSalvo, and I am an associate at Conn Maciel Carey in both the OSHA and the employment practices. On the OSHA side, I work in representing employers during inspections and investigations, as well as advising and counseling them throughout, an enforcement proceeding, dealing with OSHA citations. And then I also assist with developing and auditing safety and health programs, as well as policies and procedures. So under the Obama administration, we found that they seem to put substantial value in regulation by shaming, namely using press releases and other tools to publicly shame employers after issuing citations before employers have really had a chance to, contest the citations, provide proof that maybe these are not valid at all. OSHA would release press releases, post other things on their website prior to that time with really scathing remarks. So one form of public shaming, and I kind of just mentioned this, is the use of enforcement press releases to make really derisive and adversarial statements about employers in a manner that is available to the general public. These press releases are posted on OSHA's website, and we've seen on several occasions also picked up and quoted by local news sources, particularly if they involve, a very public incident. So this slide shows some actual examples of statements that have been made in press releases throughout, the past couple of years, and they demonstrate how negatively OSHA will present an employer, again, before the employer has even had a chance to defend itself against the citations and within the enforcement action. So under the new administration, we do anticipate, first of all, that the content of these press releases will change. We think that they'll probably become much less derisive, much less adversarial, and potentially even, not be available in certain cases until there has been some proof or some opportunity for rebuttal. Additionally, the use of press releases by OSHA increased significantly under the prior administration. So you can see on the screen here, from 2003 to 2008, press releases averaged around 148 per year, which came to about a total of 889 press releases during that specific period. From 2000 from 2011 to 2016, however, there was around 436 press releases posted a year, which is almost 4 times what it was in that prior period. And that averaged about a total of 2,780 that were released during that time. And again, as per year it increased by almost 4 times. This is way over double the amount of what it was under the Bush administration. So really significant, shows how much OSHA relied on this for purposes of public shaming. So we foresee that the number of press releases published during the Trump administration will more closely reflect the levels that we saw during the Bush administration, which means that we should see a decline in the number of press releases over the next year. This also means a likely change in OSHA policy. As you may know, during much of the Obama administration, enforcement press releases were published for citation packages with penalties greater than $30,000. This amount did increase in 2016 to around $80,000 after that penalty increase that Eric was speaking about earlier. So we think it's likely that the agency under Trump will shift its policy and further increase that threshold penalty amount that might trigger a press release. And we think that will likely increase by a pretty substantial amount, maybe closer to $100,000 before a press release will even be published on OSHA's website. So another form of public shaming that we are quite familiar with is used for employers that receive citations qualifying them for the Severe Violator Enforcement Program, also called SVEP. As you may know from participating in our webinars over the years, employers qualify for SVEP if the citations that they receive meet one of the 4 categories that you see on this slide. And I think that's really important to emphasize here, that employers qualify for this program simply based on citations. So, before any proof has been offered, before any opportunity to contest has been given, OSHA puts them into the Severe Violator Enforcement Program, which has some really significant consequences. And the most common way that we see employers qualifying for SVEP is through the 3rd category provided in this chart, particularly through receiving 2 or more repeat violations related to a high-emphasis hazard. And we will talk a little bit more about the whole repeat policy later on in this webinar. So within SVEP, there are a couple of ways that public shaming is utilized. First, OSHA releases particularly egregious press releases that identify the employer as being put into the SVEP program and includes usually at least one inflammatory quotation by a senior OSHA person or from the Department of Labor official. Second, and the employer's name is included on an SVEP log, and this log is also publicly available. It is posted on OSHA's website. They do update that log occasionally, but we see, once employers are on there, their name is on there for a long period of time, even if the outcome of the case happens to be that they no longer qualify for the program. So under the Trump administration, we believe that there are 3 potential ways that SVEP, and particularly the public shaming component of SVEP, could be altered. One way is that the agency under Trump will just completely abandon the shaming elements of the program, terminating the use of the log, and if they do issue press releases, because their policy may still require that depending on the amount of a citation package, they will use less inflammatory language in those press releases. Alternatively, and what we think is most likely during the tenure of this administration, the agency will revise the current policy so that potentially publication will not occur until a decision on the citation has been made, or at least one referencing the fact that the employer has been put into SVEP. And we think they may also try to revamp SVEP overall to ensure that the program is really only reserved for those employers that meet this whole concept of being, a bad actor. So again, we think that that is probably the most likely thing that will happen, but that'll take, a longer period of time, and we'll see it over the next 4 years. And then finally, we think OSHA could determine that there are better ways to direct its resources overall and maybe abandon SVEP altogether. We don't think that this is a super likely possibility, but that's definitely something I'm sure that will be considered, particularly if they do decide to direct more resources toward, offering compliance assistance. SVEP may become something that's much less used, much less important to this this agency under the Trump administration. And then finally, this year, 2017, is set to be the first year that injury and illness data will be published again, through OSHA's website under the electronic submission rule. So as of now, employers meeting the qualifications provided on this slide must start electronically submitting data to OSHA this year, and it must be done on or before July 1st, 2017. OSHA says that employers will be able to submit this information through a secure website provided by OSHA. We don't know if that website has yet been created or will be available, when it will be available, but that is what the rule provides for. Data can be submitted from corporate headquarters for larger companies, but it will be submitted on an establishment by establishment basis, as stated on this slide. And only establishments meeting the criteria described here will be required to submit that data by July 1st. This rule will lead to another form of public shaming because around the time of the submission, OSHA will begin publishing this data on its website. So it will be published as provided, which means that it will go up likely without context for the individual injuries and illnesses reflected in those records. So there really won't be, any sort of understanding of what this data means provided to the public who may view this information. Interestingly, actually, former Assistant Secretary Michaels made it clear that this rule is intended to nudge employers to prevent injuries because, investors, job seekers, customers, and the public will now have access to this information. He also explained that this rule would help OSHA target their resources. For employers, the most likely impacts we see of this rule as it currently stands are provided on the slide here, discouraging consumers from doing business with a particular employer, providing ammunition to competitors, potentially organized labor, scaring off current and prospective employees, and then, potentially eliminating the access to business loans for the particular employer because of the data provided, or negatively impacting insurance coverage and insurance rates. So due to the substantial impact of this particular rule, industry has actually been really vocal, provided some really vocal opposition. So we think that the rule will be toward the top of the list for the Trump administration to take some action to really, kind of change it as it currently stands. Specifically, we think that there could be a move to delay and or halt the full implementation and enforcement of the rule as of July 1st. So, this law actually did become effective January 1st, so it will not be covered in, for example, that the memo recently released that, postponed the effectiveness of several rules that were released or that would go into effect after, Trump became president after his inauguration. But we do think that the administration will push the July 1st submission deadline nonetheless. For now, that has not happened, but we do think that that is something that will be on the horizon. So. Oh.
Yeah, and I think really, I think the idea that this data will be published is in question. I think It's hard to say what they're going to do with this rule, but if I had to guess, I think they will maintain the rule, maintain the data collection element of the rule, but will not publish it online. I mean, that is the, I think industry has responded negatively about the rule in general, but particularly harshly about the publishing of the data, and that, I think, will probably change during this administration. There's a couple of questions here on the sections that Lindsay and I covered. We'll address those questions real quick because Lindsay and I are actually in the middle of a deposition, and we're going to drop off here in a second. So a couple of the questions. One is, what data is it that is expected to be submitted in 2017 in July 2017, if the rule carries out the way it is intended right now? Employers in both of those categories identified above, medium-sized and larger employers, are submitting 2016 injury and illness data, and during this first year of the rule, you're submitting only the 300A data, even if you are in that larger employer category. In future years, larger employers are submitting all of their injury and illness data, the 300 log data, the 301 incident reports, and the 300A data. But right now, it's 2016 data that you'll be submitting in 2017 if the rule carries out the way it is intended. Another very good question here about, does this data submission rule, will this eliminate or change the Bureau of Labor Statistics injury survey that goes out each year to a smattering of employers? It's my understanding the answer to that is yes, that this will replace that. That survey resulted in a tiny subset of the employers who are covered by this rule submitting their 300A data. So this will take the place of that, and BLS and OSHA will make use of that data the way they had made use of that subset of data historically. And I think that's it on these subjects. So we'll hand it over to Amanda to talk about union inspection rights. And Lindsay and I are going to drop off, but you're in capable hands. If there are any other questions, please don't hesitate to reach out to any of us. And we hope you join us for the rest of the year for the webinars that we have over the course of the year.
Great. Thank you very much. My name is Amanda Walker, and I'm going to be talking to you. Lindsay and Eric were talking kind of prospectively and kind of long-term with regards to some of the events that we expect to happen under the Trump administration. And I'm going to talk about an interpretation letter that can actually, this new administration can take action on it pretty quickly to resolve some of the controversy that's been around it. So digging in here, just to introduce myself a little bit more, my name's Amanda Walker, and I have been practicing with Eric for approximately coming up on 6 years, and I've been in the occupational safety and health legal area for the past 10 years. I started on the government side before moving over to the private practice side about 9 years ago. So that just tells a little bit about me, and I do exclusively OSHA work like Eric in all facets, from representing trade associations to doing a lot of enforcement and compliance work. So the issue that I'm going to talk about today is the union walkabout right. This was an issue that came up in 2013, and just to provide a little background on this, the OSHA Act in the OSHA inspection context authorizes employers to have a representative participate in the inspection, and it also allows for representatives of an authorized by employees to accompany the OSHA agent during an inspection of the workplace. And that's what's in the OSHA regulation that was passed in the early 70s. Just going a little bit further, OSHA has its own implementing regulations with regards to the subject, and they basically reiterated what was in the OSHA Act, and they did put another provision in it that said that unless basically you could either have an employee's representative or an employee representative participate in the inspection, as well as an individual participate that is reasonably necessary to conduct an effective and thorough physical inspection of the workplace. That third party was typically thought to be somebody who would have technical expertise, maybe an industrial hygienist, a safety engineer. It could also be a union representative if there was a union workplace. Then in April 2013, OSHA came out with a interpretation letter that was in response to a request by the United Steelworkers, and it basically was dubbed a letter of interpretation stating that non-union employees could select anyone, including outside non-employee union representatives, to accompany OSHA compliance officers during safety and health inspections of an employer's worksite. The letter contradicted OSHA's longstanding position that are still in the book, mandating that an employee representative must be an employee of the employer and has to be known as the union and this rule has become known as the union walk-around rule. This 2013 interpretation letter contradicts longstanding understanding of what an authorized employee representative is in different legal contexts, including OSHA's own regulation as well as the OSHA procedural rules, National Labor Relations Act, and OSHA's own field operations manual. But nonetheless, they did indicate that third parties that were not elected by employees or the employer could participate in OSHA inspections. So this letter came out in 2013, and it was actually rarely used. I can only think of 4 or 5 instances where it was actually employed. Primarily, one instance involved a janitorial service in the Houston area that was going, I think, was one of the largest janitorial services that was non-union and was attracting interest from union organizers. So that went into effect in 2013. After the union was participated in inspections with regards to the janitorial service in Texas, the National Federation of Independent Businesses filed a legal lawsuit challenging the regulation. Basically, the claims in the lawsuit are that it was improperly promulgated, that it was a legislative rule instead of an interpretation, and OSHA should have gone through comment and notice rulemaking. And, they point out that OSHA basically this basically allows a non-employee representative to participate in OSHA inspections and essentially allows non-union workplaces or union representatives to go into a non-union workplace. The thought was there might be some organizing interest there. It also, in their brief, they point out that lowering the criteria for when third parties are permitted. OSHA's own regulation stated that it was when it was reasonably necessary, and the interpretation lowered the standard to make it when it will add a positive contribution, when the third party will add a positive contribution to the inspection of the safety and health of a particular facility. That rule is actually still under challenge. That was briefed in December, and actually there's a good chance that the NFIB will prevail in that decision. But in the meantime, we have a new administration in place, and this issue could be easily resolved with simply rescinding the interpretation letter. This is something OSHA doesn't have to go through rulemaking for. They could simply pull that letter back and go back to their initial application and interpretation of the regulations, where an employee representative needed to be either a union representative as involved in the workplace and not somebody who was not elected by either the employer or an employee of the workplace. Just talking about swinging towards the Obama administration tended to have a stronger union protection and workers' right perspective, thinking that we're going to see a change back to the pro-employer outlook and likely to see this interpretation letter disappear. And that's one change we expect to see fairly soon, probably soon after we get the leadership into OSHA. Right now, as Eric had mentioned, PUDSNR's hearings in the early February timeframe, and then we'll start to probably see some spots filled out within OSHA as the year progresses once there's a Secretary of Labor put into place. I'm now turning it over for the future of OSHA's injury reporting and anti-retaliation role.
Thanks, Amanda. This is Dan Deacon speaking. I'm going to be talking about the future of OSHA's injury reporting, particularly the anti-retaliation rules. Just some quick introduction here. Keep this rolling. My name's Dan Deacon. I'm an associate here at Conn Maciel Carey. I've been here for almost 2 years now, and I'm an associate in both the OSHA Workplace Safety Practice Group and the Labor and Employment Group. Similar to Lindsay, I represent employers during inspections and investigations, advise and counsel employers in responding to notices of employee safety complaints and citations. And on the labor and employment side, I represent and advise employers in all aspects of the employer-employee relationship, including wage and hour disputes and claims of discrimination. I also help out reviewing handbooks, putting together workplace policies and procedures for employers. So this has been a hot topic in OSHA circles for quite some time now, dating back to May 2016, and as you all probably are very well familiar with this, OSHA's electronic injury record-keeping rule calls into question several employer policies and programs, including reasonable reporting procedures, post-injury discipline policies, post-incident drug testing, and safety incentive programs. The rule drew sharp criticism immediately from employers. Following its enactment, the rule, 8 industry groups and companies filed suit in the Northern District of Texas, I believe it was back in July 2016, challenging the anti-retaliation provisions. An emergency motion for a preliminary injunction was simultaneously filed with that, but it was ultimately denied back in November. I think it was just after Thanksgiving, November 28th, 2016. So currently, as we stand, the entirety of OSHA's electronic injury and illness record-keeping rule are in effect, including the anti-retaliation provision. But we don't think it's going to be for long, especially in light of the new administration's agenda. The anti-retaliation provisions are definitely on the chopping block here. So swift action by the administration, which is anticipated, will effectively eviscerate the rule and will likely nullify the industry legal challenge. So shortly before the motion for a preliminary injunction was denied, OSHA issued a guidance memo back in October 19th, 2016, addressing to some degree what OSHA intends by reasonable reporting procedures, and specifically what type of employee discipline, post-incident drug testing, and safety incentive programs would be considered retaliatory and violative of the new rule. But even more recently, actually, OSHA has taken further steps to insulate its efforts to combat retaliation by filing a motion to dismiss to the industry challenge, and it also issued guidance on recommended practices for anti-retaliation programs, all of which was done 1 week prior to President Trump's inauguration. The recommendations that came out on January 13th, 2007, they're intended to help employers create effective anti-retaliation programs for their workplace, and it details how employers can implement effective programs based on 5 key elements. So if you want to take a look at those, we suggest that you do so. As for internal injury reporting policies, the new rule added a new section a new paragraph to Section 1904.35 to prohibit retaliation against an employee for reporting a work-related injury. And this is actually a prohibition already explicit in Section 11C of the OSHA Act. But under this new rule, an employer can be cited just for having a policy that can have a retaliatory effect. So no whistleblower is necessary. According to the regulation, employers need to have a reasonable reporting procedure. But the rule itself doesn't define reasonableness, and OSHA didn't really explain what it meant by that in the preamble. One thing was clear in the preamble, though, is that a policy that requires either immediate reporting of an injury or a policy that creates an undue burden on employees to complete a report violates the new requirement. From the October guidance, we got a little more clarification on what OSHA means by reasonable. So reporting policies with hard reporting deadlines are going to be scrutinized closely because they can deter employees from reporting. For example, a reporting policy that requires an employer to report a workplace injury within 24 hours or face discipline. Additionally, it's not going to be reasonable to discipline employees for failing to report an injury before they realize they have a reportable workplace injury or when they're incapacitated. However, OSHA did state that employers can implement policies that require employees to report an injury or illness as soon as practicable after realizing they have the kind of injury or illness they're required to report, such as the next business day. So the key inquiry here is going to be whether the employer's policy provides some amount of time to report after the employee realizes that he or she has suffered an injury or illness, work-related injury or illness. As for workplace safety rules, the key here is discipline for violating workplace safety rules is not categorically prohibited. OSHA is ultimately going to bear the burden to prove that the actual reason for disciplinary action is that the employee reported an injury or illness as opposed to violating a legitimate workplace safety rule. So the central inquiry here is going to be whether the employee treats other employees who violated that same safety rule in the same way, even if those employees did not report a work-related injury or illness or otherwise were injured. Finally, discipline for violating workplace safety rules needs to be doled out consistently. Situations when reporting employees are disciplined more severely than other employees who worked in the same way, or when reporting employees are selectively disciplined for violating vague work rules, such as work carefully or maintain situational awareness, those are going to be subject to increased scrutiny as well, especially when they're disciplines doled out disproportionately. So ultimately here, an employer is going to need to ensure disciplinary actions doled out consistently and imposed for a legitimate reason. The new rule also snuck in provisions related to post-incident drug testing, stating post-injury drug testing may dissuade a reasonable employee from reporting work-related injuries. Ultimately, post-injury drug testing can't be used as a form of discipline. That was the main message. But we do know one thing is certain here, that blanket post-injury drug testing policies are going to be strictly prohibited. However, the rule does permit the following drug tests, as you see on the screen here: pre-employment drug testing, random drug testing, tests to comply with another law, for example, Department of Transportation mandatory post-accident tests for drivers, when it's required by a workers' compensation insurer, including premium reduction policies. And I mean, the key here also is that not all post-incident drug testing is prohibited. According to OSHA, the rules tailored to prohibit only drug testing for reporting work-related injuries or illnesses without an objectively reasonable basis for doing so. So when evaluating whether an employer had an objectively or has an objectively reasonable basis for doing a drug test on an employee who reported a work-related injury or illness, OSHA's inquiry is going to be whether the employer had a reasonable basis for believing that drug use by the reporting employee could have contributed to the injury or illness. And if so, it's going to be objectively reasonable to subject that employee to a drug test. As for safety and incentive compensation programs, the October guidance, the memo provides some guidance on how bonus and compensation programs could operate properly, but the record-keeping rule raises a lot of question about the validity of those bonus programs and incentive programs. So as you can see here, OSHA is mainly concerned about the chilling or retaliatory effect of certain types of programs, and if you look on the screen here, all the thumbs down are programs or policies that would be considered impermissible, and the thumbs up would be likely permissible. So generally, if a reward or bonus is based on injury rates, it's not going to be permissible. In contrast, rewards or bonuses for complying with legitimate workplace safety rules is going to be permissible. And as for the last two there about supervisor, manager, and executive compensation, under the current rubric, bonuses for supervisors and site management that are based on injury and illness rates are going to be more heavily scrutinized and likely impermissible. But bonuses for division management, front office executives are generally going to be permissible. They're sufficiently removed from that OSHA is concerned about deterring reporting. So what we believe here under the new administration is that the anti-retaliation provisions are definitely on the chopping block, and it's likely going to be done soon. Swift action should be taken within the next few months. There's a couple options that the administration can do to essentially curb this rule and get rid of it. One is to initiate the formal rulemaking process. That's going to take a little bit of time now. So some quicker options are issuing new guidance documents. OSHA had issued the new guidance documents, the one in October that I spoke about earlier, and the one just recently in January, roughly a week and a half ago. So they could write new guidance documents and issue letters of interpretation on what it means by reasonable reporting procedures, when post-incident drug testing can be done, and what permissible safety and incentive programs look like. They can also curb enforcement with a budget rider. Eric mentioned this earlier. There's going to be a change in enforcement philosophy likely, so they can essentially limit the budget for anti-retaliation enforcement efforts, and ultimately this will settle the industry's legal challenge by essentially rewriting the rule. So with that, I'm going to turn it over to Micah Smith.
Thank you, Dan. As I bring up the tail end of this wagon train, I notice that we are over our time, so I will go quickly, but hopefully effectively and with good information for you. I'm going to talk a little bit about the repeat violation policies and how you might see those things change from the Obama administration to the Trump administration. First off, a little about me. I'm the newest member of the OSHA team here at Conn Maciel Carey. I have been doing this for quite a few years. I've been around long enough to remember when we saw Obama's OSHA riding in declaring there's a new sheriff in town. So it's interesting to see them on the way out and with another new sheriff in town. So I'd done a lot of work with a variety of clients, but certainly a lot of time with petroleum refiners and chemical manufacturers, a lot of heavy industry, but also some other healthcare and commercial bakeries and things like that. Think of myself mostly as a litigator, so I enjoy doing battle with OSHA whenever we get the chance. All right, so OSHA's repeat violation policies. We tend to see, and you've seen this from everyone else, we tend to see the history of OSHA in two parts, sort of a pre-2009, the classic OSHA, and then Obama's new sheriff in town, OSHA. And so as you see on this slide, we saw big changes from 2008 to 2009, and the use of the repeat policies were certainly a part of that. What we saw was the use of repeat citations as a way to shape behavior. As you saw earlier, the penalties for a repeat citation are as much as 10 times the penalty for a serious citation. So you certainly have the ability to have a larger effect on an employer just with a single citation. In an effort to better enable them to use their power under the repeat citations, we saw a couple changes under Obama's OSHA. One change was instead of focusing on single work sites, to look more at the broader corporate family and to see different locations under the same corporate structure to be a similar work site, one that could qualify for repeat citations. So you might have a plant in New York that got a citation, and 6 months later you have one in Florida with a citation. They were a lot more likely to use the repeat citation, even with that geographical discrepancy. We also saw them expand the look-back period under the Bush 43 OSHA. They looked back for a 3-year period, and they thought that things older than 3 years were far enough in the past they wouldn't consider it. Obama's OSHA changed that to 5 years, so it gave them a bigger window for issuing those repeat citations. We also saw a much more proactive targeting philosophy, and I'll talk more about that in just a minute. Our next slide shows the trends as they relate to repeat violations. And I think you can see here there's a very clear trend of an increase in the share of repeat citations issued. You will note, though, that the raw number of repeat citations between about 2008 and 2016 was fairly stable. There's some increase, but not too much. What's most remarkable is that the share of the citation pool went up significantly from just over 3% to just over 5%. So you see many more, or as a percentage basis, repeat citations, while the number of inspections was decreasing, and even the number of serious citations were being issued. It is fairly remarkable that in this era where we saw fewer inspections, that they were continuing to reach their same numbers of repeat citations. So the changes that we talked about earlier certainly played a role in this. Having a 5-year look back made the agency much more able to issue more repeat citations, and the same for using different work sites under the same corporate family. So it's a clear trend under the Obama administration there. Our next slide here talks about the proactive targeting philosophy. That was the last piece of how they use the repeat policy to their advantage. Another way of increasing your ability to issue repeat citations is just to show up more often at the same place. If you have a 3-year look back and you don't usually tie in separate work sites under the same corporate structure as the same employer, and you wait more than 3 years, you just don't have a chance to issue a repeat citation. So what Obama's OSHA did was certainly use a more targeted enforcement approach. We heard about that every year from the administrators, that they were looking for specific employers to go after. So they showed up a lot more often. One way they did this was using national and local emphasis programs. This is not something that was only done by the Obama administration. We certainly saw a number of them start under Bush 43's administration, but we certainly did not see very many of these enforcement programs or these emphasis programs retired. If you look at OSHA's website right now, they have more than 10 national emphasis programs, and each region has somewhere between 7 and 20 emphasis programs running at the same time. So we have an emphasis on many, many different hazards, and the Obama administration kicked off a few new ones and certainly retired very few. So of note are silica, combustible dust, and lead. All started in 2008 under Bush's OSHA, and they have not yet been retired. So if we look at where we are sort of in the world as we move into the Trump administration, what do we think is going to happen? We think that there's a good chance that OSHA will ease off on its enforcement or on its use of these levers. So a classic hallmark of the Obama administration was using the enforcement powers to leverage, to try to shape employer behavior in a way that they had not tried before. So if we see a change in philosophy under the Trump administration so that they are trying to do less shaping of the corporate culture, I think the repeat citation policies will be an easy way to do that. We could see them return to just a 3-year look back instead of 5s. We could see them backing off some from treating an entire corporation and even related corporate structures as the same company eligible for repeat citation. And we are also likely to see less targeted enforcement. So we could see some of these emphasis programs rolled back, retired, or we might also see fewer follow-ups or a more formal exemption for employers that have had a recent inspection. If you have an inspection with citations, OSHA will reserve the right to do follow-ups on those items, but may make it a policy to not show up at that work site again for a year or two, and would make the argument that, hey, we'll just go inspect other work sites instead. So this is, as much of what we said, it's something of speculation, but definitely keep an eye out on early days of Trump's OSHA to see how they interpret their role. If they seem to be maintaining the role of Obama's OSHA of trying to shape the behavior of companies in a particular direction, whether for whatever reason, whether it's to support the populist, some of the more populist statements of President Trump, or for other reasons, possibly related to international trade and companies that do less business in America, you might see them continuing to follow some more aggressive enforcement. But if we see a more classically Republican or more of an anti-regulation OSHA, and those promises have also been made, we could see a much more effective rollback or a back off of enforcement. So that's it for the part on a repeat citation, and that's the end of the program. We do have an entire series. I'll let Dan.
Yep. Thank you guys for joining the first webinar that we put forward here in 2017. Our next one's going to be February 8th on slips, trips, and falls, and we hope to see some of you there for that. A full list of our webinar series can be found on our website. And please check out our blog. We post blog articles every so often on recent OSHA news and relevant topics. And if you guys have any further questions, please feel free to reach out to us personally. Our contact information is in the slides, which is going to be made available to all of you guys. Following this webinar, we'll get that out to you. And with that being said, we hope you all have a good day.